Hello ladies and gentlemen, I hope you are all doing fine. Again, my name is Mutiaba Conrad, and once again we are meeting to look at evidence law. Our topic for the day is going to be character evidence. Character evidence is very important when you're looking at the various forms of evidence under evidence law. So today allow me to look at character evidence in detail. Again, I invite you students to always have your Evidence Act because it's very, very, very important for evidence law. It's the primary source of law, and always have your cases right. Ladies and gentlemen, character evidence is covered under the Evidence Act, specifically by sections 50 to section 54. Read them in detail, understand them, and you will be able to appreciate character evidence. It's not expressly defined. When you look under the law, character evidence is not expressly defined by the Act, but it is covered and explained by the proviso to section 54 of the Evidence Act, which states that in sections 50, 51, 52, and 54 of the word character includes both reputation and disposition. Furthermore, the section goes on to say, but except as provided in section 52, evidence may be given of general reputation and general disposition, and not of particular acts by which reputation or disposition were shown. Ladies and gentlemen, section 50 to section 54 of the Evidence Act, in summary, is simply saying that character evidence includes both reputation and disposition. The fundamental question here that arises then is, what is disposition? Disposition, ladies and gentlemen, is simply the tendency of a person to act in a particular way. That there is a tendency of person X to act in this manner. That is what we call disposition. Then the second question now becomes, what is reputation? Reputation is public opinion on someone. What other people's opinion are on you is what we call your reputation. What you should note, ladies and gentlemen, from the onset is that character evidence has a general rule and exceptions, and we are going to look at them in detail. The general rule governing character evidence is that character is not admissible as evidence. The general rule, I repeat, is that evidence of character is not admissible in court. You cannot adduce evidence, as a general rule, pointing to one's character, of course, which includes both their disposition and reputation. Forget, ladies and gentlemen, that is the general rule. But that general rule also has exceptions, meaning that there are circumstances where one's character can be used as evidence, and it will be accepted or it will be admissible by the courts of law. And that is what we are going to look at. Number one, the first exception is the nature of the case. Okay, there are certain cases, depending on the nature of that case. There are circumstances where court will look at the nature of a case. Depending on the nature, case can accept the character, okay, of a party as admissible evidence. Secondly, the nature of the parties. For instance, it is evidence of the character of the accused. Okay, the nature, court will also look at the nature of the parties. What is that nature of the parties? Like we said, for instance, is it the evidence of the character of the accused, or it is the character of the plaintiff or character of the defendant? Okay, which of the two? Is it the accused? Is it the defendant? So court will also look at that. Okay, character evidence in reference to an accused person. Okay, under section 51, 52, and 53. So court will look, okay, at the nature of the parties. Who is that party? Is it the accused? Is it the plaintiff? Is it the character of the defendant under question? And we shall look at that in detail. I invite you to look at section 51. Go and read it in detail, which provides that in criminal cases, the fact that the person charged is of a good character is relevant. This is in line with the presumption of innocence. Okay, so that is also a principle of law under character evidence. Also look at section 53 of the same act. This section, however, provides that an accused person during cross-examination may be asked questions that tend to incriminate him or her as to the offense he or she is charged. This section again lays down one of the important principles of character evidence. Okay, let's proceed now, ladies and gentlemen, to look at exceptions to the general rule in admission of character evidence. Remember, we have already laid out the general rule, and we said the general rule here is that evidence of character is not admissible. Now we are looking at exceptions. Under what circumstances will such evidence of character be admissible by courts of law? The first, ladies and gentlemen, is under section 52, where the accused gives evidence of his good character. So here we are looking at a situation where the accused person is before court and they start to give evidence of their good character. Okay, the other side will also be allowed to adduce evidence of his bad character to negative the positive impression that they are creating. And of course, this will become the exception to the general rule, where character of a party, okay, will be admissible by court. I invite you students to look at the case of Starland versus DPP. This is a case of 1944, SC page 315. In this case, just briefly to discuss the facts, the accused person was charged with forgery and he gave evidence of his good character. He called a witness to say that he was a person who had never been convicted before, and he's a very good person who is moralistic. Court held in giving its judgment that the court allowed prosecution to adduce evidence of his bad character and stated that the accused can at that stage be cross-examined as to his good claims of his good heavenly character. During trial, evidence of witnesses who can establish bad character may be adduced, and of course in such a circumstance, then that would serve the exception to the general rule which I earlier discussed for you. Let's proceed to look at the second exception, which is under section 52 B of the Evidence Act, which is where there is evidence of previous convictions. Okay, where there is evidence of previous convictions. That section, when you read it, it provides that where there is proof that the accused has committed or been convicted of another offense, which is admissible evidence to show that he or she is guilty of the offense with which he or she is charged, then in such circumstances, character evidence will be accepted and it's admissible. I invite you to look at the case of R versus Rodney, a case of 1913, volume 3, KB page 468, regarding the aspect and the principle of previous convictions. Also, don't forget the case of Makindi versus R. It's very important to look at it. It establishes and lays down clearly this principle. It's a case of 1961, East Africa, page 327. In this case, evidence of previous beatings was admitted as portraying on the accused's character. So again, this case illustrates where character was admissible, where court accepted it as an exception to the general rule. Some of you should not confuse this topic. There are students that can confuse this topic. So please make sure you don't confuse the general rule and the exceptions. The other exception, ladies and gentlemen, is under section 52, clause C of the Evidence Act. And it states that where the accused's defense imputes bad character on the complainant. So here we are looking at a situation where the accused puts up a defense, but that defense is trying to show that the character of the complainant is a very bad one. In such circumstances, the complainant will be allowed to adduce evidence of the bad character of the accused person to try and negative the bad impression created. Ladies and gentlemen, I invite you to look at the case of Royston versus R, a case of 1953, 20 Yaka, page 147. In this case, it was stated that if the imputations of bad character are an integral part of the defense of the accused, without which he cannot put his defense squarely and properly and fairly, then he cannot be cross-examined on previous criminal history. Okay, that's a very important principle to note. Also see the case of Katwe versus Uganda, a case of 1964, East Africa, page 477. Also look at the case of Rex versus Turner, case of 1944, volume 30, CR Appeal Cases, page 18. Court held in this case that where the accused was charged with rape and he put forward the defense of consent, this did not amount to an imputation on the character of the complainant to render the accused a subject of cross-examination of his previous convictions or bad character. So again, this case helps to draw or put in context the aspect of that exception under section 52, clause C of the Evidence Act. The other exception, ladies and gentlemen, is under section 52, clause D of the Evidence Act, where the accused gives evidence on his co-accused. So here we are looking at a situation where two parties are charged together before court, and one of the accused person gives evidence against his co-accused. In such circumstances, he will be allowed, or character evidence will be admissible by court on the character of the other co-accused person. I invite you, ladies and gentlemen, to look at the case of Murdoch versus Taylor. This is a case of 1965, volume 1, All England Law Reports, page 406. Murdoch was charged jointly with Lynch for the offense of receiving cameras, knowing them to be stolen. In cross-examination, the appellant said that he had nothing to do with the cameras and they were entirely Lynch's responsibility, meaning that he was trying to paint the picture that Lynch was the one who had committed the crime and that not himself. On appeal, court held that the evidence given by the appellant was evidence against Lynch. Therefore, questions against the appellant's previous convictions were properly allowed as they pointed to the appellant's credibility, and as such, the exception would be invoked. Ladies and gentlemen, those are the exceptions under our Evidence Act. Let's now proceed to look at the character evidence in civil cases. Look specifically, okay, at section 50 and section 54 of the Evidence Act, which lay out the principles concerning character evidence in civil cases. This can either be character of the plaintiff or defendant or the witness. Section 50 provides that in civil cases, the fact that the character of the person is such as to render a fact probable or improbable is irrelevant, except insofar as the character appears from facts otherwise relevant. So what section 50 is saying is that in civil cases, the character of the respondent is irrelevant. Okay, that is the principle that is laid out under there. Exceptions to section 50. So some of the exceptions to section 50 is that evidence of character is relevant to show that bad behavior was not an accident. So that is the first exception to section 50. But also the other exception can be found under section 54. Section 54 of the Evidence Act is the other exception to section 50, and it states that where bad character affects amounts of damages. So here we are looking at a situation where one's bad character is affecting the amount of damages that the other may receive. that is the exception. And ladies and gentlemen, look at the case of Goodry versus Oldham's Press, a case of 1967, volume 1, Queen's Bench, page 333. This case illustrates very well. The brief facts of the case were that in March 1964, the plaintiff was convicted for robbery of 120 mailbags and being armed with an offensive weapon, and he was sentenced to 30 years. In July 1964, the defendant newspaper published an article which referred so many times to the claimant and established the leading role she played in the Great Britain train robbery, in which £2.5 million was stolen from the mail train. The issue in court, the main issue in court, was whether evidence of bad reputation was admissible. Court went on to hold that convictions within a relevant period of the plaintiff's life were cogent evidence that the plaintiff had a bad reputation and were admissible indeed in evidence in mitigation of damages, and the evidence of March 1964 was as such admissible by the courts of law. So this case clearly illustrates in very good detail the exception and under what circumstances it would be applied. I also invite you, ladies and gentlemen, to go and look at the case of Scott versus Sampson, which is a case of 1882, QBD, page 491. Court said in that case that in mitigation of damages, only general evidence of reputation may be adduced, and it's not permissible to adduce evidence of specific facts. But however, it's permissible to plead such matters as directing attention to the relevant sector of the plaintiff's life. So again, same thing, this case lays down the exception as earlier explained under section 54. Ladies and gentlemen, let's proceed now to look at the character of witnesses. Of course, here witness character is irrelevant. Here the principle is that such character of witnesses is irrelevant, but his or her credibility may be called in question, okay? And that is specifically under section 154. So go and read section 154 for purposes of grasping the principles on character of witnesses. Also look at section 137 of the Evidence Act, and section 137 provides that witnesses to the opposite party may be discredited by bringing in their bad character, and this usually happens during cross-examination as provided for under section 137 clause 2 of the Evidence Act. So go and look at that section and be able to read it in detail. Let's now proceed to look at the character of the defendant. Okay, what is the rule, okay, on character evidence concerning the character of the defendant? In civil proceedings, this is not ordinarily an issue. Okay, so every time we're in civil proceedings, normally this is not an issue, but however, it may become an issue under circumstances laid down under section 54 of the Evidence Act. Remember, we already looked at it, and I also encourage you to look at it in detail. However, the general rule is that the character of the defendant may not depend on whether the defendant has been convicted of a criminal offense. Okay? What has to be established is his behavior in respect of civil matters at issue. This is unlike, for example, in criminal matters, where past conviction is relevant. Please draw the distinction, okay? In practice, courts have been very reluctant to accept character of the defendant based on past convictions. Look at the case of Hollington versus Newtham, a case of 1943, KB, page 58. In action arising out of collision between two motor cars on the highway, the plaintiff alleged negligence on the part of the defendant driver. He sought to give evidence while in court. of a conviction of the defendant of careless driving arising out of the same facts in a criminal matter. Court went on to hold that evidence of previous convictions is not admissible in civil action for being contrary to justice. So this is a very important principle to grasp. Please distinguish how court would approach the same in civil and criminal as highlighted above. Ladies and gentlemen, I thank you very much for your time. I hope this has been a fruitful discussion. Again, in case you want to always have notifications and more of these videos, please feel free to subscribe to my channel. And in case you have any questions or comments, please drop them down there in my comment bar. God bless you. Bye-bye. See you next time.
Songo ganide ku kamera.